Number 152, People versus Wragg. Counsel, go ahead. Would you like any rebuttal time?
Yes, Your Honor. 1 minute.
1 minute. Go
Shirley
ahead.
Gorman for Mr. Wragg. Willie Wragg, if it please the court, this case demonstrates two things that are unfortunately not uncommon in child sex crime cases. And that is when a prosecutor's tactics and misconduct go unchecked, that constitutes the ineffective assistance of counsel. And that was true in the Fisher case and true in this court's Wright decision from July 1st of this year. And this case also demonstrates that the legislature gives prosecutors discretion in child sex crime cases to avoid the worst sentences, gives them a safety valve. This legislation started out as mandatory for all second child sexual abuse offenders, assault offenders, and it was a life sentence. It was to be sentenced as an A1. And this is the statute.
Are you talking about the CPL now, counsel, or the penal law?
The penal law.
The penal law.
The penal law. But that's the penal law section came in with the CPL section. And the CPL section said what all of the other laws say, which is if information available to the court or to the prosecutor prior to sentencing shows this person might be a second offender, a persistent violent felony offender, the people must file a statement. This statute was changed. That language was deleted to say before trial commences, if information is available to the people, they may file. And
So we have to strictly construe that?
I believe you do, because I believe it was a deliberate choice. And it was for legitimate reasons. Because these sentences are so harsh, if a prosecutor wants to prosecute someone without using that status, it gives them the ability to do that.
But doesn't the penal law say that if the requirements are met of the previous crimes, previous convictions, that they must be sentenced, receive enhanced sentencing?
It says they must be sentenced if the procedure in 419 is used. And the procedure in 419 is the process that says it may be filed. So I submit that if a prosecutor looks at a case and says, I want a plea out of this case, and I know I'm not going to get it if this person is treated as a second child sexual assault offender. So I'm not filing that thing. I am going to arrange a plea bargain where he's treated as an ordinary second offender.
Was Mr. Wragg offered a plea in this case, or did he seek one?
No. And it's clear at the record on page 591.
No to which? No to which?
No, neither. There was no mention at any point in this record about any plea from arraignment until sentencing.
So he wasn't evaluating anything about whether to take a plea or to go to trial.
Right. But his
He's
attorney...
always planning to go to trial.
Yes.
And your position is 7007 of the penal law says he must be sentenced as a predicate offender for this type of crime only if the prosecutor abides by CPL 419?
And files before trial.
And where's this?
I'm sorry.
Judge Evans.
I just, you know.
And again, at 591 in the record, this lawyer says this never came up. We never talked about this status at all. And there are reasons to acquire the people to provide that notice before the trial commences.
But how does your theory of this apply because the statute 400.19 says anytime before trial commences. So what if the plea bargaining process has already taken place and there's a plea and it's never mentioned or anything? When does this come into play then?
For a plea, I submit they don't have to file it. And for a trial, they don't have to file it. They may file it. They may choose not to file it to treat this offender that way. But Armbruster...
What if they make an offer, it's rejected, and they say, okay, now we're going to trial, and now we're going to...
Perfectly appropriate. And I think that's the safety
valve. How does that effectuate the purpose that you say is for the timing of all this?
That's the safety valve for them to work a plea if they need one with regular status. But if they have to go forward with trial, to use the higher stakes, and it puts the defendant on notice, and it avoids retaliation after the trial.
Well, there's two questions that rise with that, Ms. Gorman. One of them is that if the plea isn't being worked out, they can file it any time before jury selection. So if the plea falls apart and they say, hey, you're lost, we're filing it, you have nothing to say. I get concerned that you say it's a I don't say a tactic, but it's a weapon that the people can use, and you're insisting that they use it. You're saying from now on, if the Court of Appeals says so, file that notice every single time, because if you don't, the Court of Appeals is going to say you can't. So if I was the DA and we were to find your way, I'd photocopy them.
Well, I think that's the people's argument, is that it's required in every single case. My argument, it's never required. It's discretion for the people, like sexual misconduct.
What I'm saying is
versus rape.
you're suggesting to us that we make a decision favorable to your client that will then tell the people under no circumstances are you not to file. Because even though it says discretionary, the Court of Appeals is going to throw you out of court if you don't file it. You can always withdraw it, but file it. And I'm not sure that that's what we want to do.
Well, I'm not sure they can withdraw it. There's no statutory authority.
Why would you
to
object?
withdraw it. Well, of course, no one would object.
So, yes,
But-
they can withdraw it.
Well, I would submit they have to file it before trial to show that they're not being vindictive, to make sure that the attorney's behavior, the defense attorney, if I'm a defense attorney and they haven't filed this notice, but they can, and I'm in the middle of a trial and I'm worried that my decisions somehow are going to result in them invoking that power, I would be very concerned. I think that's a good reason to.
Counsel, let me just ask you, let's just stay with the text as opposed to speculating about anything. So, as I take it, some of what you've said strikes me as a little bit of speculation, but let me just stay with the text. So tell me why this attempt to harmonize these two sections does not make sense. 70.07 is mandatory. Once someone is convicted who falls in this category, it's a mandatory enhancement. You have to follow the procedures to get this mandatory enhancement, and that means that they have to file a statement. And all that 400.19 does is set out the procedure, but it allows the possibility for the prosecutor to file the statement before someone is convicted, because 70.07 only applies to someone who's convicted. All that 400.19, 2, I believe it's 2, does is allow for them to file this statement before someone is convicted. Why can't you harmonize these two statutes this way?
Well, because the legislature changed the language that's in every other statute like this, and they used language that is in no other statute may. And so they were changing the law. They were allowing the people, nothing would prevent the people from filing it in a second felony offender now before trial. So why use may?
Well, okay, I'm sorry. Doesn't it say it has to be for someone who's convicted? Have I misread the statute? How can you file it if someone's not yet been convicted if they're still at trial? What did I miss in the statute?
Well, I think that, again, they changed this law as it was going along. And is it inartfully written? Yes, clearly.
All I'm
Because,
suggesting is that there might be very well a way to look at the text and say, no, there's not a mistake. It is clear. When someone's convicted, this is what happens. But there is this one opportunity for the prosecution to proceed before conviction. And they may, but that doesn't mean you don't enhance the statute. That doesn't mean you don't have to have the statement before the sentencing.
but there, the statute says before trial commences. It doesn't say.
I understand,
before-
because at
I
that point,
know.
there's no one convicted.
Right, right. And that's the people's argument.
Okay, Counsel,
Thank you.
you'll have your rebuttal. Counsel?
Yes, Your Honor, Jeffrey Corker for the people. And that is indeed my argument and said better than I managed to say
But what's the
it.
purpose, counsel, of the may or the discretion as opposed to must file?
Right. I think it has to do with the fact that these are very harsh punishments. And so this allows for a procedure where you can adjudicate that before the trial, so the defendant then, if there's a question about whether or not these provisions would apply to the defendant after a conviction, the defendant can figure that out ahead of time and can have an accurate assessment of his exposure before going to trial.
But that didn't happen here because no statement was filed before the trial.
That's correct. And so, I mean, that is, the prosecutor, by not filing a statement, and this is true regardless of predicate status, the prosecutor, by not putting the defendant's exposure on the record, leaves herself open to a potential, Lafler versus Cooper and Missouri versus Fry problem. We get those 440s all the time where the defendant says, hey, I was misadvised about my exposure ahead of time. And so that can be a problem. Here, I don't think there was any consideration on either side about a plea. So I think that didn't really come.
That's this case. We've got to deal with this statute, and it seems to suggest that you do it before trial, and in fact, it says so. So Ms. Gorman had a look at it that's a little bit different, and I can see that. Halfway through the trial, you guys decide, I think we really got this case in the bag. We're now going to file it, and we're going to put this guy away for a lot longer than we would have at the beginning when we weren't sure we had as strong a case. I pictured it, I don't know if I'm thinking like a legislator or what, as saying if that first one is not like the second one, if for whatever reason the child's circumstances were much different, they said we're not going to press this. We're just going to go for the one. They make that determination early, and then they're done.
Oh, but that's only if it's discretionary. I mean, I don't think it's discretionary. So if it's not discretionary, then, I mean, the defense attorney has an obligation to, and that's the Lafler or Cooper, and the defense attorney has an obligation to inform his client about his accurate exposure and so forth. So you just don't have to adjudicate it necessarily beforehand.
I'm missing that. You said it's not discretionary?
I don't think it is discretionary. I think 70.07 makes it mandatory. If you are a predicate, you must be sentenced as a predicate. And I think counsel says that it says something like you must if the CPL provisions apply. If you compare 70.07 versus the other predicate sentencing statutes in Article 70, the other ones actually say something closer to that. This one starts out and it says if you have a predicate, something like if you have a predicate conviction, you must be, whereas the other ones say if the CPL procedures in 400, whatever it is for each one, are met, then you must be. Here it's more emphatically a predicate must be sentenced as a predicate.
Counsel also said, I'm sorry.
No, please.
Counsel also said that 70.07 applies if the statement has been filed under 419, but I didn't see that anywhere in the statute. Is that anywhere in the statute? I don't see it.
No, I don't think that it says that he has to be sentenced as a predicate if the people have filed a pretrial statement. No.
Well, 70.073 says the provisions of Section 400.19 of the CPL shall govern the procedures that must be followed to determine whether a person stands convicted.
Right.
Right?
Right. Yeah.
Still got the must there and the shall.
Right.
It's saying these are the procedures you've got to follow.
Right. Right. But again, you have that may in 400.19. I mean, I think.
So is subdivision 3 talking about, what, in order to make the determination of whether you're a predicate, those are the procedures?
Right. Absolutely. And I think if the import here is the people get to choose and so, I mean, this is a very strange way to construct a statute that has that outcome. I certainly wouldn't argue that this is the most perfectly crafted statute that makes it super easy. But I think that the
other statutes, counsel, where the people are required or may file prior to sentencing, is there anything precluding the people from filing a statement before a trial, pretrial?
Well, I mean,
in one of the statutes that says it must be filed before sentencing.
You could file a statement, but the court wouldn't do anything with it. Whereas as I read 400.19, the court can then adjudicate that question.
It triggers the possibility of a hearing and so forth.
Correct.
There's a challenge from the defendant.
Correct, and that's I think the difference really in the CPL procedures on those points.
Just to clarify, it may be a request for you to be repetitive. What would be the reason that a prosecutor would indeed do this before the trial commences?
Try to get a plea.
To negotiate the plea.
Yeah.
So the two of you agree on that, that's really to try and encourage the plea agreement.
Yeah, yeah, and I think in that sense, allowing that to be adjudicated ahead of time can be efficient.
To avoid the trial.
Right.
Well, let's suppose you didn't have this law, the CPL section. Are you suggesting that somehow the DA couldn't say, hey, by the way, your client was convicted of the same felony charge 3 years ago, and if you can take a plea now, or if you don't, he's going to get sentenced as a second felony offender?
I mean, the prosecutor could say that, sure.
Sure. So I don't understand why we would put a section in the law that says the DA can do what it's always done.
No, because the hearing is if you can adjudicate it at a hearing, which you otherwise wouldn't be able to.
Oh, before the
With the court making a determination.
before the trial. Before the trial.
Correct.
And you're saying that we can ignore that?
I'm sorry, I guess
You're saying we can ignore that the DA can say, we're not doing that because we don't want to have a hearing. We want to convict the guy, and then we'll have, and then we'll say he's a second felony offender.
Right.
So we go back to why is the statute there then?
I guess I'm not understanding the question.
If you
because
can always take a plea, you don't need it for a plea. If you
No,
can
no, I'm saying I think you do.
Stick with me.
I'm sorry.
If you can always use it at sentencing, you don't need it. So there's no reason in the world for 400.19 to be in there, it seems to me, other than the fact that everyone knows at the beginning of the trial that we're talking about a second felony offender on a sex abuse case.
Yeah, and to allow you to potentially adjudicate the question of predicate status before trial, at a hearing presided over by the judge.
But provide some benefit if perhaps the defendant has some credible challenge.
Right,
to the
exactly.
fact that they're a predicate.
Exactly.
And they want to clarify this beforehand because that may change the plea negotiation posture of the case.
Absolutely.
So if that's the case, then it's a very important benefit to the defendant that you should not be ignoring.
Well, no, because again, I go back to the defense attorney has an obligation to his client to explain.
I know, but if I'm understanding what Judge Rivera asked you was, it gives a benefit to the defendant to find out, what's going to be coming by challenging that first offense. And you said exactly, you can challenge, they can challenge the first offense before they get into the trial. So it's a benefit to them, and you're saying, but we don't have to do that at all. We don't have to file at all because it's just there.
Right, but we do. But if we don't file it, we do it at some risk. Is my point.
What's the risk?
That he may have an ineffective assistance claim on a 440 by saying, "I didn't know I was going to be facing predicate." We get those claims all the time.
So we should protect you by finding in favor of Ms. Gorman.
I think you should interpret 70.07 the way I think it was intended, which is to make this mandatory and to not give discretion on. These, when we're talking about people who repeat sexual abuse of children, we are talking.
Let me ask you, counsel. 400.19(2) says when information available to the people prior to the trial against the child indicates that a defendant may have. Is there any point in time when you do not have such information before trial?
Geez. I would think we would generally know the criminal history of the defendant before trial, and certainly should.
And in this case, there was a Sandoval hearing, so everybody knew, correct?
Correct.
But then why was it so hard for the court to get you to file, the people to file the statement?
I can't answer that. Why? There's that appearance after the adjournment and it's still not filed, and I can't explain that at all.
Okay, thanks, counsel. Rebuttal, counsel.
I may address the ineffectiveness. This attorney did what the attorney did in Wright, which is undermine his own strategy, his own theory of defense, by allowing proof by telling jurors that this child witness had made an identification 3 weeks after the crime when they should not have heard that.
Why isn't that legitimate strategy? Isn't it sort of assumed that there must have been an identification made? Otherwise, how would we know it was him?
I'm not sure jurors would assume that, particularly when you have the neighbor daycare provider saying, I gave them a name when they gave me a...
So Tiffany didn't testify here that when they went to the greenhouse and knocked on the door, the victim said, that's him, initially?
Yes.
So she testified. So there was, that made, defense counsel knew that might come out.
Well,
And
that
was
was
an-
a different person. That
I
was
understand-
not my client.
That's the point.
Right.
The whole defense was a misidentification.
Right.
And if the victim initially identified someone else, then wouldn't it be strategic for defense counsel to bring up to the jury, well, you know, you can't believe this child because, you know, she's going to misidentify.
But you're telling
Client.
them that 3 weeks after the crime, she picked your client. And that's something they would not know because it was only by photo array, and that testimony was wholly inadmissible.
Okay, counsel, thank you. Thank you both.